Well, hello, everybody. Welcome back to Radio Entrepreneurs. Again, if you've forgotten my face, my name is Jeffrey Davis. I am host of Radio Entrepreneurs. Also, I am founder, CEO of Mage LLC, shockingly, since 1985, providing executive leadership development, organizational work, strategic work, family business transition work, and kind of shocked how long it's been. I've known this person on my screen almost as long as we've started the firm. Met him in a networking group myself many, many years ago. He looks exactly the same. And so I'm talking about the one and the only Mark Furman, partner, member of Tarlow, Hart, and Rodgers. Welcome back, Mark.
Hi, Jeffrey. Great to be with you. You certainly look the same. And as for the way I look, it is time for an eye exam, Jeff.
Well, I remember, you probably had a little bit more gray suits and ties back then. We all had suits and ties.
Right, as well as hair and whatever. But anyway, so I wanted to talk today about the subject of terms and conditions. We keep reading about all the supply chain problems, the shortages of different parts and how hard it is to get them and how much more they cost, all since the, some combination of the beginning of tariffs a few years ago under the prior administration, and then the impact of COVID, which has been overwhelming. So I always tell clients, can we take a look at your terms and conditions? Because if you are buying things or you're selling things, these terms and conditions, one of the most boring subjects for business owners, have real life consequences in times like these. In fact, half of the cases that I'm getting now relate to these kinds of problems relating to the availability of goods. So I'll give you an example of, somebody agrees to supply X parts at Y price. What happens when the cost to the supplier exceed, in some cases dramatically, what the supplier has agreed to sell them for? Your terms and conditions are going to decide how big a problem you have. And these problems can actually be threatening to the very existence of a business. You take the example of what happened with cost of wood. Well, wood increased in cost by 400%, 500%. People or more, people who were committed to supply wood under purchase orders they had accepted under the original price, what do they do when it's going to cost them 3 times the amount that they can sell the wood for? So what's going to decide it? Well, if your terms and conditions give you an out, that can save your business. And if they don't, it puts you in the world of gray, where you may not be able to get out of the contract. So attend to your terms and conditions. You don't want to be relying on a hope and a prayer. There's
Mark, you're bringing up a really important point. Okay, here I'll put on my consultant hat, and my client is asking me about terms and conditions. I'm going to want to read it to make sure that there's nothing that triggers the prospect from not doing the deal, because I'm concerned about building top line. But if you were reading it at the same time, you and I might have a debate. And a lot of times when I'm reading terms and conditions, there's no lawyer involved.
Well, that's right. And a reason that there's no lawyer involved is many people don't attach importance to it, who are business owners, because of course they want the business. But like in all, terms and conditions represent contracts. What's the contract between the seller and the buyer? And just like if you're selling a business or buying a business, or selling real estate and buying real estate, when you sell goods or buying goods, there's this tension. You want to lock in the other side, but you don't want to be locked in. So it's sort of more art than law in a way, is how you do strike the right balance for you and your company. So there are the, express terms that relates to when you can get out of a particular contract, but there's also things that indirectly impact, what are the ramifications of inability to perform? Things like, if you are a supplier of goods, you want your terms and conditions to eliminate a buyer's chance to sue you for as much as possible. So you'd want to have in there that you can't recover indirect damages, lost profits, consequential damages, incidental damages. You want to kind of drastically reduce the damages that you can be liable for. You want to have a choice of law clause, because we got 50 different states and the laws are different in different states, and the attitudes of courts are different, and the damages that are recoverable can be different. So the choice of law clause is very important. Also, a choice of forum clause. Where can any dispute be settled? Do you want to be in arbitration? Do you want to avoid the possibility of somebody bringing a class action suit against you? Do you want to be, if you want to be in court, do you want it to be in a forum, a state that's most convenient to you? Or do you want to be able, you want the other side to be able to sue you in the forum, the state most convenient to it? None of this matters when everything goes great. When it doesn't go great, all this stuff matters. It matters on the cost of the fight. It matters on what your exposure is. It matters on whether you can get out of the contract or not. It matters, but it's boring. So even though it's boring, I think it would be wise for business owners to at least periodically look at their terms and conditions, at some point have I'll call them a non-deal breaker lawyer, talk through the issues with them. Because, you don't want a lawyer who's just focused on the negative. You want someone who understands business and understands the importance of the top line, as you say, because I have to say, without top line, you don't have a business. But at least so you've thought through, and with assistance, the pluses and minuses of different clauses. And what you want as a buyer is different than what you want as a seller.
Well, I think you're making a good point. We had somebody on the show today who's in the food business, and unlike most of his competition, he has increased his distribution substantially. But a lot of people I know are having trouble getting product and selling product. And that's even true for professionals. As you know, a lot of law firms like yourself are very busy through COVID. And so delivery responsiveness has changed for a lot of law firms, and face-to-face meetings, court dates. So I think reviewing your letters of engagement, your contracts, everything, I think are important, because it's just going to protect anyone from potential liability or receivable issue, collection issue. There's a lot of problems that can come from that. And I think I think your concept of being boring is safe is very smart. I know that's your positioning statement for marketing.
I am Mr. Excitement, Jeffrey, as you know. But
well, I'm one of those few people actually does find you kind of exciting. I don't know what it says about me. So Yeah, but you're right. And these letters go out all the time. People don't want them reviewed. I know for me personally, and I'm not even an attorney, I had to say to someone just yesterday, you should have me take a look at that. I'm already on retainer and you're not paying for that. And, the idea of bringing, and they're always like, oh, I don't want to send it to my attorney. What's the bill going to be? But it's nominal compared to the expense that it's going to cost the firm.
Right. If you can prevent a litigation, it's incredibly valuable. And if you have to bring suit and you have an attorney's fees clause that if the folks don't pay you, that they're responsible for your collection costs, including reasonable attorney's fees. You have a default rate of interest in your terms and conditions. All these things are helpful as you try to negotiate disputes, because the goal is to stay out of court, to stay out of arbitration, so that you can spend your time making money as opposed to dealing with historical problems. So anything that helps you minimize the impact of historical problems on the business is worth an occasional investment. These aren't things you're going to review every week, but if you do it once and make sure that they're consistent with your business as opposed to something you get off the internet that bears no relationship to your business, or then, and maybe you'll look at it again in 5 years. It's not a major investment, but it's an important process to talk through.
Well, always very practical advice from you, Mark. You're a very practical person. Again, you can be found at the law firm of Tarlow, Hart, and Rodgers. But if someone wants to contact you directly, how would they do that, Mark?
I can be reached at 617-218-2025 or at Furman, Furman, at TBHR-law.com.
Thank you very much, Mark. We look forward to speaking to you every week on Radio Entrepreneurs.